Good afternoon, sir. Can you hear me?
Yes, sir.
What's your name?
Richard Levitt, Your Honor.
Could you say that again?
Richard Levitt, Your Honor.
Are you here as a witness?
Yes, sir.
Okay, let me give you a proper name. Oops. Not sure I got this right, but I'm going to put you in the waiting room and while we bring the others in, all right? So stay right where you are.
Yes, sir.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon, Jordan.
Good afternoon, Your Honor.
I haven't turned the recorder on yet. We are live on YouTube for the time being. I have a witness who's checked in and I didn't quite get his name. I thought he said his name was Richard Levitz.
Yes, Your Honor, that's our witness.
Is that the correct last name?
Yes, as I understand it, Levitz.
Okay, I wrote it with an S.
We didn't know if he was going to appear today or not.
He's here. He's in the waiting room. And Karen Gibbons is there. Let me get things turned on here. Be ready to start. Close a lot of these applications from this morning. Well, prepare to go live here.
You know, unfortunately, my desk is not as big as counsel table in a courtroom.
Well, again, it looks like you're ready to land some airplanes at Kalamazoo International Airport. It certainly makes it better that we can hear everything. I've had a lot of struggles. I think we're going to have some struggles with Mr. Levitz, too.
My client is trying to appear, I think, by
She's
video
here.
and telephone. Okay.
Well, let's see how well she's here. There we go. Mr. Levitz, I understand you're here as a witness, and so we're going to keep you in the waiting room until it's your time to testify. So you're logged in, you're in the right spot, but I'm going to set you aside. So I haven't forgotten about you, but we've got some other business we have to transact here.
Okay, sir.
Good afternoon, everyone. Everyone's here in a timely manner, and I do appreciate that. This is the scheduled time and date for a termination of tenancy hearing in the matter of Village Manor versus Karen Giddens and all other occupants. Ms. Giddens, can you hear me?
Yes.
Very good. Representing the defendant is Harold Welch from Legal Aid of Western Michigan. Representing the plaintiff of Village Manor is attorney Jordan Yancey, and the Village manager, Kristen Borcher, is also present. This was filed as a termination of tenancy case for some material violations of the lease. There was a challenge to the jurisdiction of the case because the notice to quit was, I think, 28 or 29 days given on the notice, but much more time had passed before the plaintiff actually filed the action. So counsel briefed and argued that issue, and I denied the motion, but that's preserved. Then there's an issue before the court. The defendant has requested an adjournment and also filed a motion in limine. The plaintiff filed an objection to the adjournment, and as I indicated in our email exchange, we set aside 4 hours for trial on the merits in this case, which is 4 hours it's hard to come by. And both parties are represented, both parties were prepared to proceed, and I didn't want to adjourn it, and neither did the plaintiff. So, Mr. Welch, do you wish to do anything additional regarding that? You indicated you would address it on the record once we got here.
Yes, Your Honor. Thank you for the opportunity to address. Just for the record, we have 2 pending motions in limine. We filed one yesterday, I believe. But regarding our motion for adjournment, Your Honor, it should be noted that the plaintiff requested and got no leave to amend their complaint. So they relied upon the court rule that allows for amendments within 14 days. However, when the defendant wants to rely upon the same court rule for time to answer their amended complaint, they complain and they object. Your Honor, what's good for the goose is good for the gander. So we do want an adjournment. And one of the things that's come to light, plaintiff, in responding to our motion to adjourn, says that it's immaterial because her complaint, her amended complaint, is almost exactly the same. I'm sorry, Your Honor, I got disturbed by a call. So the thing is that I have discovered in preparing for today's trial, given all my other commitments, that the plaintiff is not the real party in interest. So that would be one of our responses to the amended complaint. Also, in the amended complaint...
Stop. Tell me about that.
Yeah. I'm looking for the document. It is a corporation out of Lansing. FHC 3 Village Manor LDHA LP. A limited partnership. It is not, Village Manor is not the owner of the property. So we don't have the real party in interest, and that's something that I would bring up in our answer to the amended complaint. In addition, plaintiff in their amended complaint cited no regulation. All they did was refer to a state agency. Now, this lease is governed by federal regulations. 24 CFR and some of the parts are governed the termination of this tenancy. You know, I am as shocked that how many unrepresented people may be going to court with a plaintiff who's not even citing the proper federal regulations And in this day, when people can look things up on their internet, they're depriving them of the opportunity to be truly informed about what's going on. So that they should be allowed to get away with this while the defendant's represented by counsel is also alarming, Your Honor. 2.402 is very, 2.401 is very clear about what must be attached to the complaint. It's not permissive. It's not if plaintiff counsel feels like it or is having a good day. It's mandatory. So for all those reasons, Your Honor, and now what is really amounting, I think we mentioned this in our second motion in limine, that these problems are compounding to the point that now we have a constitutional due process problem with the proceedings and the pleadings. So for all those grounds, Your Honor, we object to proceeding. We don't have the real party in interest before the court.
All right, well, Ms. Yancey, what's your response to that?
Well, Your Honor, I do believe the proper plaintiff is identified in the complaint. The lease agreement is between defendant Karen Giddens and plaintiff Village Manor. They are an agent of that corporation. They are the proper plaintiff. As far as
your sound's not too good.
Sorry, Your Honor, I'll move my. I was indicating that the lease between the parties is between Village Manor and Karen Giddens, so I do believe we have the proper plaintiff identified in our pleadings. Additionally, I find it somewhat ironic that defendant is arguing insufficient time to prepare for an amended complaint when he filed a motion at 3:30 yesterday, which was impossible for me to file a response to. I had to quickly file a response to his motion adjourn that he filed Friday and I received Monday. So the fact that he's arguing insufficient time when he's filing motion after motion, up to the day before trial, I find that a little interesting in that it almost lends to the suggestion that he was almost counting on us to file a motion to adjourn to address all these motions to file. I do believe the complaint filed is proper. The proper plaintiff is identified. The amended complaint filed simply highlights terms of the lease in which the regulating authority is listed.
Jordan, I'm still losing your sound. I know we had internet problems yesterday all across St. Joe County, but that's a more localized problem. But yeah, the recorder couldn't hear you either.
Okay, I'm trying to speak as loud as I can, Your Honor. I don't know what the issue is. I was just indicating that the complaint filed simply highlights what was attached in the lease filed. In one of the multiple motions that defendant filed, he alleged that no lease was even attached, which, as this court is aware, filing cannot occur without a lease attached, as it has to be served upon all parties. So I'm not sure where the information defendant's counsel was getting and that there was no lease provided. I would argue that we are ready to proceed today. The plaintiff is the proper plaintiff, as the lease agreement is between Village Manor and Karen Giddens. I don't believe an adjournment is necessary to address the amended complaint, as it does not materially alter the plaintiff itself. I feel that the defendant's frivolous filing of motion after motion was an attempt for us to request an adjournment to provide them more time, or Ms. Giddens more time in the home, but we are ready to proceed today, Your Honor, and I would ask the court to deny the verbal motion to adjourn.
May I respond, Your Honor?
Well, it was a verbal motion. He filed it in writing, but we didn't have any hearing on it, so he did file it. One thing I'm reluctant to do, I'm reluctant to give up this 4-hour block of time that we set aside to try this matter on the merits, but I'm also really reluctant to have to do this twice if there's some technical defect before we even get to the argument on the merits. And this isn't a situation where the defendant is in custody, but Village Manor is in some urgent desire to get Ms. Giddens out of the property. And it was set on fairly short notice, but we've been trying to be prompt in the scheduling of these landlord-tenant matters, and we have a lot of them. We've had a lot of these termination of tenancy matters, which frankly take a lot of court time to deal with. There are two motions in limine that we have yet to address, and there's this motion about who is the proper party in interest. And we're not prepared to argue the proper party in interest at this time. What makes you believe, I mean, the lease says Village Manor versus Karen Giddens. What makes you believe that, and the complex is properly known as Village Manor. What makes you think they're not the proper party in interest?
Yes, Your Honor. I went on the internet to Michigan.gov, the Michigan State Housing Development Authority's Affordable Rental Housing Directory. And there, the name of the property is Village Manor, but the owner is FHC 3 Village Manor, LDHALP. Now, plaintiff's counsel may be correct that the lease says Village Manor, but MCL 600.5714 says a party entitled to possession. So if Village Manor is acting as manager of the property, they're not the ones entitled to possession. Only the owner is. And I think, if I remember correctly, these SCAO form complaints state that you have to say the plaintiff is the owner or the owner is entitled to possession. So, for those reasons alone, Your Honor, and I respect that and understand that you have a lot on your plate and a lot on your docket, and you need to conserve economy. But I want to also briefly respond to counsel's allegations that we filed frivolous motions. We file a motion, it's up to the court, as I understand it, the district court sets motions for hearing. So that we were forced to file them so close to the trial date is because of the errors of the plaintiff, not because we're trying to do anything with suspect motives.
Your Honor, the motions in limine you filed were to object to the witnesses that I had prepared on my witness list, which can be determined at a trial. That's up for the court to determine at trial through testimony. Just because he doesn't like what I've indicated the testimony will be does not make them inadmissible witnesses.
Well, one issue we have, it's going to take us a while to argue the motions in limine. And I am concerned, it's really just a distinction without a difference. It could be repaired. Village Manor has probably filed several hundred complaints over the last several years, all in the name of Village Manor. And perhaps they should be filing as Village Manor representing the corporation. But as I indicated, I don't want to do it twice. I don't want to go through all this and find out on appeal that we didn't have a proper party in interest. So I'm reluctantly going to grant the motion to adjourn, but we're going to use this time to argue the motions in limine. I'm going to excuse, do you need Mr. Levitz for your motions?
No, Your Honor. Thank you for asking.
Mr. Levitz, can you hear me?
Yes, sir.
This is Judge Middleton once again. It looks like we're going to have to adjourn this trial. We're going to argue some legal motions in the meantime, but we won't be taking any testimony today. So I'm going to excuse you. You can go on about your business, and they will serve a new subpoena on you or ask you to appear when we get to our next date. So as far as today goes, you're free to go on about your business. Okay?
Okay.
All right. All right, there were two motions in limine filed. And again, they were filed in fairly short order, and so the plaintiff didn't have a chance to respond. Let me flip to the first motion in limine.
And Your Honor, I just want to say on the record, if plaintiff counsel wants more time to prepare for the court to hear those motions, I do not object.
Jordan, are you ready to respond to the motions in limine?
Well, Your Honor, since we are adjourning the termination of tenancy trial, I would ask for time to respond to these properly, as I did receive them just a few days ago.
All right. Well, then that sort of goes toward the fact that we probably should have granted the adjournment. The first motion in limine, I'm not sure I even understand it.
Would you like me to fill in the blanks, Your Honor?
Yes.
Okay. So as we point out in the authority we cite in that motion, it says the court shall rule on preliminary matters. One of the benefits of doing that is so that the record is not cluttered with inadmissible matters, and we don't have a jury in this case, but so that there's no confusion of issues. The first motion has to do with the fact that they threw in some language in the notice to quit about people coming and going at all hours of the night. Now, this motion kind of, behind this motion, the court's got to see the fact that we don't know what we're facing here. What is this allegation really about? And let me sidetrack a little bit. The federal regulations that were not cited by the plaintiff, which the court would have access to if they were on the complaint, require specific notice such that a party can prepare a defense. That is required by federal regulation. And Your Honor, that is 24 CFR section 882.511 federal regulation. So it says the notice of termination must state the reasons for the termination with a sufficient specificity to enable the family to prepare a defense. One of the weeds we might get into if the court starts hearing evidence about people coming and going at all hours and days of the night is that my client has a disability and people come to assist her. So what is wrong with those facts being on the record? Well, there may be a question of issue preclusion or collateral estoppel if my client wants to pursue a claim for violations of the Fair Housing Act. And again, this is one of the problems which we're trying to answer in our responsive pleadings to something that is pretty nebulous and we're not sure of. So given those facts, we're saying let's not have any testimony about these people unless you're going to show some foundation that we're talking about a substantial material violation of the lease, which is the federal statutory standard for having grounds to evict. So that's why we're trying to keep this evidence out about people coming and going, because we don't want to have to get into the weeds without having filed a counterclaim for violations of the Fair Housing Act.
Well, all right. In my prosecutor days, this would have been probably referred to as a bill of particulars. Nobody uses that anymore, but it is a pleading that was filed by competent defense attorneys to say, what do you intend to prove that I did that violated the law? When, where, what happened? Now, just because she may have people coming in at all hours of the night to help her with her ADA concerns doesn't mean they can scream and yell and pound up the stairs and do that sorts of things. So it is pretty vague and nebulous. People come in at all hours of the night. When, where, how. So in the response to that motion, Plaintiff will indicate when and under what circumstances, dates if possible, tenant violated that clause of the lease. And you're right, you call it going out in the weeds. I guess we could get caught up in that, but it's a legitimate reason why management is trying to terminate this tenancy. There are rights of the defendant, to be sure, but there are also the rights of all the other tenants in the building who apparently are aggrieved by some of this conduct. All right, so Ms. Yancey will have, and the problem is, we've got a problem. There aren't enough hours in the day and there aren't enough days in the week. We've lost 5 landlord-tenant days in the month of April because of Good Friday and Judge Patterson's vacation and my vacation. And so we're already strapped for time, and these continuances are probably going to put us into May. And Ms. Giddens, do you understand that your landlord wants you to move?
Yes.
And you don't wish to move, you'd like to stay there in your apartment?
Yes.
So my strong advice is, whatever you're doing that is irritating them, you stop doing it. And you also understand that if they prevail at the time of the hearing, you will have 10 days to move out, or you would be subject to being evicted short any stay or appeal. You don't want to go, they want you to go. That's why I'm here. Judges are elected to decide these difficult questions. Now, this is entitled a motion in limine. A motion in limine is a Latin term for excluding evidence, excluding or limiting the admissibility of evidence. So your lawyer has requested that I limit the amount of evidence that the plaintiff can produce, specifically regarding the people coming and going at late hours, which are disturbing the other tenants. They're going to provide some specificity in their response to this as to the times and dates when this conduct occurred. Now, there's a second motion in limine, again, to exclude evidence. Let me flip to that one.
Your Honor, I had one thought too, and that is, if you want the plaintiff to amend those allegations, that maybe you allot some time for a plaintiff to file a second amended complaint, and then allow me 14 days to respond, with the understanding that plaintiff and defendant counsel will exchange documents by email too, as the United States Postal Service is saying more and more that they can't keep up with a regular mail service.
It's about to get worse. The Postal Service is announcing limiting hours and limited days of the week, but we're all noticing the delays in the mail. All right, I think that's, as I said, we're going to go into May anyway. Plaintiff has 14 days to file an amended complaint. He may wish to include who he alleges to be the rightful owner of the property, and defendant has 14 days to respond. Second motion in limine.
Would you like me to fill in the blanks on that one as well, Your Honor?
Well, yes. In this case, it's a hearsay.
For clarification, this is the one filed at 3:30 yesterday, correct?
Yes, March 23rd, it's stamped. And in your defense, you'd like to have an opportunity to respond to it. Otherwise, I guess we would have been doing this on the fly in the middle of this trial. All right. Plaintiff lists a witness who will testify about some anonymous caller alleging drug activity. And you're objecting to the hearsay evidence regarding an anonymous caller. You wish to speak to that motion further?
Yes, Your Honor. Just briefly, I would say we're still back to that same fundamental problem, and that is the federal regulations of the Housing and Urban Development Agency require that in Section 8 evictions that a notice to quit specify with enough specificity that a person can form a defense. And Your Honor respectfully is obliged to follow the federal regulations in this attempt at termination of tenancy. So here's the problem. First, hearsay. I was shocked when I saw any attorney listing that they're going to have somebody testify about an anonymous phone call, and I was surprised that I had to file a motion in limine about such a thing. But it's clear it's hearsay. It's also clear that it was not in the notice to quit. Criminal activity was never mentioned in the notices of termination. If we're going to get into allegations of suspected drug activity, then I submit, Your Honor, that the plaintiff needs to start over with a proper notice to quit. But we can't continue to go on violating court rules and rules of evidence and statutes and federal regulations, Your Honor. Thank you.
I looked several times in the course of this at the notice to quit. This lease is quite lengthy. It's 17 pages long. And the relevant paragraphs are 7, 8, and 23. So Ms. Borchert prepared a notice to quit alleging violations of paragraph 7, 8, and 23. Paragraph 7, reporting changes to household income or family composition. A household member moves out, or an adult member who is reported as unemployment comes into income. And then there's some other paragraphs. So that has to do with not reporting income of other participants in the household. Paragraph 8, members of the household and occupancy. Tenants must live in the dwelling unit, and the dwelling unit must be the tenant's only place of residence. Tenant shall use the unit only as a private dwelling place for himself and other household members listed alone. She is the only person on the lease. So there's an allegation that there's an unapproved tenant in the premises. Those two are pretty straightforward. Not reporting income and unauthorized tenant. 23, however, is very wide open. Paragraph 23, which is included on page 11 of the lease, has essentially the material non-compliance, and it includes all kinds of things. Drug-related activity, illegal use, abuse of alcohol, criminal activity, flight to avoid prosecution, violation of conditions of probation, other good cause. So criminal activity is included within the broader purvey of paragraph 23, but there are about 15 or 20 subparagraphs, so it's pretty broad. So again, plaintiff is looking for exactly what it is that's being alleged that they did to violate the lease. I don't remember. Was there an addendum or anything with that, Ms. Borchert? There's a number of lease violation notices which were included with the pleadings. May 6th, disturbance, housekeeping, unauthorized occupants, unauthorized pets, inoperable parked vehicle, This is by a previous manager. And some other previous notices of violations. Ms. Borchert, are there still alleged to be pets there?
The last time we were in there, there was a cat there, yes.
I had two other cases. One involved pit bulls, where the people were not to have any animals, and they had pit bulls terrorizing the neighbors. And even during the pendency of the trial, the pit bulls were still there, which made the judge's decision about whether to terminate tenancy, irrespective of any other issues, fairly straightforward. The next one was another no pets, and the person still has cats in the premises. You can see the cat dishes in the pictures. She indicates the cats are still there. She left the home, apparently left the cats there. Your lease says no pets, and apparently there may still be a cat there. So that's something we're going to be exploring. It shows a disposition to disregard the terms of the lease. Anyway, Jordan, paragraph 23 encompasses a lot of activity that could be perceived as a material violation of the lease. And I'm sure in preparation for your trial today, you have a number of things that you intended to elicit. I guess the defendant's entitled to know what it is that you're going to allege that she did.
And Your Honor, for the record, with our initial filing, photos were attached as well as police logs to
Yes.
further reflect the specifics of the violation of 23. However, I'm happy to, in my second amended complaint, specifically cite the paragraph 23 violations that we are alleging. I will confer with Ms. Borchert on this.
Your Honor, there's another problem we face, and that is that 24 CFR section 880.607 states that no grounds at trial may be used unless they're in a notice to quit. So the thing to do here is to start over with a proper notice to quit. If you're saying there is illegal drug activity, say who, what, where, when, how, and why. If you're saying unauthorized people are living there, say who, what, where, when, how, and why. Whatever it is you're accusing this person of doing, put it in a notice to quit, because this is not going to stand on appeal. And so I'm giving fair notice that this is the law, and if the law isn't followed, this case is not going to stand up on appeal if we lose at trial.
I'm not convinced that you're correct that all of that has to be in the notice to quit. You're asking for either a bill of particulars or a motion in limine to request it. She's on sufficient notice to know what it is that she allegedly did. But now that she's represented by competent counsel, you're asking for some specificity into what it was that she did. They've been giving her notices for months to tell her she's a violation of the lease. So this didn't sneak up and bite her in the ankle. So I don't think it makes the notice to quit defective. There was the issue with the date, but you're asking for more specificity, and she's proposed to put it in the second amended complaint. Jordan, is 14 days enough to do that?
I believe that I can get it done by next week, Your Honor.
Well, 14 days from today would be April 7.
I have other cases obviously set, as this court's aware. This is not the only case I have on my docket.
Well, we're all in that boat. It isn't like we're just sitting here. This is the only thing we have to do.
I will get that.
Well, I'll give you 21 days if you request it.
I can get it done by the 7th, Your Honor.
All right. Defendant has 14 days to respond.
And Your Honor, I'm not trying to be argumentative. I'm just trying to point out that federal law requires that there can't be a trial in anything that's not in the notice to quit.
Your Honor, the paragraph 23 of the lease provides for multiple provisions. I believe that's sufficient as far as the notice to quit.
Well, it certainly is quite broad. Uh, 14 days. So April 28th. 21. Wednesday afternoon, May 19th.
What time were you thinking, Your Honor?
1 p.m.
Okay.
for trial on the merits.
Right, I have that open.
Jordan, does that work for you?
It should, Your Honor. I don't believe I will be sitting co-chair on the jury trial that's scheduled that day, but it should work for me.
I have some reservations about our ability to try a jury trial in May. I know Judge Stutzman has high hopes. The state's current COVID rate is at 12%, 12.7%. It's not that high here in St. Joseph County, but I don't know why we're doing so poorly here in Michigan. We're at the bottom of the pile as in terms of other states. All right. I would certainly like to get this resolved. Ms. Giddens, this is of importance to you. It has to do with where you get to live. If you are in fact evicted, it may make it difficult for you to go anywhere else. In fact, it may preclude you from being in other federally subsidized housing. So that's always something that's in the back of everyone's mind. But they're serious about this. Your attorney is serious in your defense. So I'm just saying, whatever the things that you've been doing that violate the lease, in their mind, I would encourage you to not do it. We're gonna have this matter delayed for about a month and a half. In the meantime, you're still under all the terms and conditions of the lease that you have. No unoccupied tenants, no loud or disturbing behavior. There were some serious sanitation issues about how unclean the hallway was and the apartment was. There's some issues about somebody spray painting things on the wall. None of those have been proven. They're simply allegations in the complaint. But just be careful between now and we have our next hearing date. Now, the other thing is, if you decide to just move and put this whole dilemma beside you, that's certainly something you have a right to do as well. But absent either of those things, we're going to prepare to have a trial on May 19th at 1 o'clock.
Your Honor, I had a proposal, especially considering now that we're coming back May 19th, if plaintiff and plaintiff's counsel is willing to go to mediation, because of my client's financial situation, I think we can arrange for cost-free mediation for her, and I suspect it probably for the plaintiff as well. I'm not sure about that, but maybe we can reach some resolution in this case.
All right, well, let's discuss that. The advice of rights that I give to tenants has a clause for mediation if the matter can be referred to the Citizens Mediation Authority. And I've yet to do it because both parties haven't agreed to it. This case may be appropriate for that, absent a knockdown, drag-out trial, to try to send it to mediation and either rectify the situations or agree to move. Ms. Yancey, that was just proposed, and you don't have to commit to it, but I'm asking you to consider whether we should do a referral to mediation And we can certainly do that before the May 19th trial date. You can discuss that with your client.
Yes, Your Honor, my concern again is cost to my client. She does not have, or my client does not have the assistance of free legal counsel. I am having to bill on all the work I'm doing.
Well, the citizens mediation would be very low cost, and the parties they can go independently without counsel or with counsel. But this is something Kristen's gonna have to take up with her management also. So I would ask that you respond to that within 7 days. I have a good deal of respect for our local citizen mediation services out of Berrien County. I don't abuse it, but I use it maybe 6 or 8 times a year with very great likelihood of success. So that is an alternate option. I'm going to do a memorandum regarding my rulings here, and I'll put that in there as well. I'll do that immediately when we finish so I can still remember everything I just did. But we've got our time deadlines for filing of the second amended complaint, time deadlines to respond. She will file more specificity in the pleadings. Within 7 days, you'll let me know whether you're interested in a referral to mediation, which I can facilitate. For either of you, are there any additional things we should put on the record?
Not for the record, Your Honor, but I had a question. You're doing all your trials by Zoom. I'm just so much more comfortable in the courtroom. So I wondered how you're handling that in your district court.
This will continue to be by Zoom.
Okay, thank you.
Yeah, I did 40 years of my career in the courtroom, and the last year has been all by Zoom. I haven't had anyone in my courtroom, with the possible exception of a prosecutor here and there sitting in one of the seats, in many months, probably since last spring. We've managed, as you know, I've said this a few times, we're doing everything. We're doing landlord-tenant, and we're current with it, although we have a lot of demand cases. We're current with our general civil docket. We're current with our small claims docket. We're current with our felony preliminary examination docket and pre-exam conferences. We're current with all of our criminal misdemeanor cases. The only thing we can't do is a jury trial. And we have a large number of misdemeanor jury cases which are backed up. Every Wednesday was jury trial day. We haven't had a jury trial in a year. And so I've been using Wednesdays for landlord-tenant hearings. At some point, jury trials are going to return. And you can't, at this point, do a criminal jury trial remotely. There are some jurisdictions that have tried to do a civil jury trial via Zoom. There are some confrontation clause issues of doing a criminal case by Zoom. At any rate, we're going to be doing civil by Zoom for the foreseeable future. And we're going to have a lot of a lot of other cases to do. Frankly, I'm proud of the fact that we're handling every other aspect of our docket. And some jurisdictions are not. Some jurisdictions haven't done a prelim since May. Some jurisdictions close to your home are very backed up in civil pleadings. They're sitting in piles all over the place.
That's true, Your Honor.
We're doing the best we can, but we're going to be Zoom civil for a while. All right. Anything else, Jordan?
No, Your Honor.
All right. I'm going to go do a memorandum of my rulings on the motions, and I will submit that to you, and I'll block those dates on my calendar, and maybe we'll resolve this one way or the other.
Thank you
All
very
right.
much, Your Honor.
Thank you.
Thank you. Okay. I have some work to do here.
Yes, you do. I'll be looking forward to that.
Oh, I'm sure you will. I'm disappointed we didn't get where we needed to go, but I think we had problems. Won't be the first time I'm disappointed I didn't get to where I needed to go. All right, we'll end the live